break no ma yeni nkomo kakra say Chief Justice asem na wo say dem bi o na ye pede o pese say court no enye ma no after say bi no ma court a enra kra for one decision ni ade aba na ye ne ye Delanyo Eric Alifo president edema Lawyers in Search of Democracy. Council Marchen,
how are you?
By the grace of God and you, Council.
I am very, very well.
Well, sir, and you said be a pin wouldn't mean Kakurana
radio.
I met in Yaka, but they are more comfortable with English when she
exactly what the best now baby a technical and what wanted to say law now they are my why
Mati, I'll try.
Enra yenya 4-1 decision by the Supreme Court. Me pacha na eno ye dien porte specifically to the public no I acquire 4-1 against who?
Okay. Good morning to all your listeners. Now, what is happening is that also some people are there. Now, typically MPP people, they wanted to stop or truncate the process. Also, from beginning to also even minority in parliament, they were trying to challenge every step of the process. And press conference, lame source, and we told them that the president is not doing anything wrong. And the process should go on. And all the people who are filing various suits, the essence of all their suits is to stop the process. Now they are putting it in various different ways. They are challenging in various different ways. The first one, the MP. I think the MP from Ashanti region. He challenged the process and said that because they didn't give the petition to the Chief Justice answer now, President the Council of State wanted to determine.
Asefwa the end now can was me. Yes.
Now the person interest say, the same end that they want to achieve. All the various suits. But I say the different people are taking different legs, different sides.
Okay.
But the result of is to stop the process. And the two people, they also just look for something and say, okay, one person said that he saw that some of the members of the committee had a meeting with a lawyer who is representing one of the petitioners. And he also said because of that, they had not that they even had a meeting, he saw them at a restaurant. And he also rushed to court and said they should stop. This is the president. The suspension of the Chief Justice was supposed to exercise his discretion according to certain guidelines. Now, guidelines, name guidelines, one publishing guidelines, they are the name process are offer as suspended Chief Justice, and they should stop the process. And the same thing. They wanted to try to put injunction on the process and said that. Now, one will answer now, Uber filing injunction or court. You have to file a main suit. Uber challenging process no or a now, upon that, then you will say that because what you have filed, it will take some time for the court to determine all of that. And it's a process, no say, and stop the process, no. And then after they look at my suit and they realize that, oh, I have a case. Then the process may have ended already, and then I will lose all the things I'm fighting for. Anti court no offer injunction to process no so until my suit is settled or my suit is heard and is determined. Now this one is a trick because the suit no it can take months. It can take months to be resolved. Until all of them they will first file something and say that well we have brought this to the court. The court should look into it. And we know that it is going to take the court some time for the court to resolve this. And so before the court to look into it, please stop the process. So the end result is for the process to be stopped. The committee should stop working. Now, the Supreme Court decided 4-1 to say that no, this is a constitutional process that is going on. We haven't seen anything wrong that the president has done or the committee is doing. And we cannot agree to we cannot agree to what you have filed. So that is it. That is the another one. It's the same thing. And see what the Chief Justice has found is rehashing.
Yeah, because meba Chief Justice ne so de so say Chief Justice we de onu amu onu a se ba ko ne de ase adofo bi we sim ye say but we ye onu an de a wa file ne de how different from is it from the previous ones na for filing, you know?
But before them, be per se, your listeners should understand that all this is a coordinated effort that they are making. And see, though the other people, and your Chief Justice and filing those other ones, but it's a coordinated thing. They all planned it. And see, another person will file, another person will file. And I believe that the Chief Justice's one is the last one in their strategy. Wow, and the Chief Justice, the things is asking, listen, first one, Chief Justice, before the committee will sit, yet he says, Chief Justice, or per se, hearing on public, on telecasting live, that will be what is going on over there. That is but if you go into the Constitution, the Article 146.8, it says that the proceedings should be in camera. It's clear, very clear. It should be in camera. It shouldn't be public, shouldn't be made public. And the reason is that if the allegations they make against the Chief Justice, if they are so horrible, and then after everything they find out that it is not even true, and they set the person free, but the public would have heard all of those things about her already. That is why the framers of the Constitution, in their right senses, decided that this thing should be done in secrecy, or we call it in camera. But the Chief Justice, what is asking for in this news shoot is that she herself can waive that secrecy or waive that in-camera hearing and say that I want everybody to see how the hearing is going. I don't know whether they are of a sympathy, public sympathy, or whatever, I don't know. So that is why she wanted. So that is the first demand is making in the news shoot that she filed. That and before the court will make that decision, they should stop the process. If they stop the process and the court decided that it should be public, then to be public. But in the case it's going, the committee hearing is going on, before they will determine her case and say, oh yes, she has a right to waive the in-camera hearing, then it will affect their right. That is why they are trying to put the injunction. So, but clearly the Constitution is very clear. Say, these proceedings should be in camera. And so we are expecting the court, the Supreme Court to come. I don't know whether it's hoping that maybe there will be some new judges that will sit on the case, on the panel, and decide that yes, indeed, she has the right to wait. But that right, we haven't seen it anywhere in the Constitution. They quoted several provisions of the Constitution. Those several provisions of the Constitution, they do not say anything about these particular proceedings. Some of them say fair trial. So you quote Article 19, for instance, that says everybody deserves fair trial, and say because everybody deserves fair trial, I want my hearing to be in public. No, but there's a provision specifically about removal of Chief Justice from office, and that provision says that the proceedings should be in camera. So you can't say that there's an Article 19 somewhere that says that everybody has fair trial. So for me, my understanding of fair trial is that this thing should not be in camera.
You can't fair trial as a lawyer. Na munyina mukosunya amrano. Fair trial na say family TV so na obi ahwebi ohun. There's nothing like that. Fair trial, the fair trial just means that if they are confronting you with any issue, they have to let you understand that this is the issue we are confronting with. They give you the right to also bring your lawyers or whoever, bring your witnesses. They give you hearing. That is all fair trial is about. That is all fair trial is about. It doesn't say whether all the cases that we have been doing in Ghana in our courts, are they in public domain? No. Are they, if I say public, do they telecast them live for all Ghanaians to see? No. It's just open court. But this particular proceedings is protected. It's protected by the Constitution. It says that this particular proceedings, it should be in camera. Okay.
So they will not be allowed the press there at all. So why is the same Chief Justice, if the President has started these proceedings and has started disclosing this matter to the public, they would have gone to court and said that, oh, the Constitution says it should be in camera. Why is the President revealing the things? And so the President has violated it. That's what they would have said.
Okay.
But because now that the President is doing the right thing, they now are saying that no, for us, we want it in camera. And so you say that this is much ado about nothing.
No, sir, that's why even counsel in this way, they are even forcing the President to do the wrong thing.
To do the wrong thing. That is what I'm saying. They are forcing the President to do the wrong thing. You see, this is very clear. It's not this is not about the discretion of the president.
Okay.
So the president will decide that, I want to do it in camera. No, the law is there that it should be in camera.
Okay.
It should be in camera. So if the president on his own has decided to do it in the open, they would have challenged it in court. Now that the president is doing the right thing, they now are saying that no, we want you to do the wrong thing.
Oh, now as a former chief justice, when in cases are in camera and on camera,
yes.
And in this case, all prefer say in fact cases are and our case in camera and famra bontini.
Yes, when they just want to create confusion for the president. And if the president, if they agree to do this, then the same people now, you will be shocked. So even she will say that she wanted to waive that right, so and the matter should be in public. You will be shocked that some of their people will come again and challenge that also because if the president allowed this to happen.
Okay, but Faba Kunsuni, sir, Rachel now can say, Omone justices Nimienu. And one of the complainants now, meaning some friend complainants, petitioners no, and lawyer Kwakusia our restaurant. Now and then lawyers, Mushia judges I am Mokwachia mana because I judge do asama esa on any yaka.
There be only judge yaka. Now, any common say lawyers and judges who go out and be having between and eating and all of that is not something that is common. Now, there's nothing also that bad a lawyer and a judge. Me that I'm here. The last time I went to visit the judge in the house, there's no law against that. First of all, we have to also understand that a lawyer that sorry denied it. They said it didn't happen. But even if it happened, you don't know even what they discussed. You can't say that if they went after the committee hearing. Let's say if it happened after the committee hearing, they all closed and they all wanted to go and eat. Why? They were all lawyers before. They were friends before. And then they decided to just pass it and go and eat. That matter, the only thing is that the matter that is before them will not be discussed. That's all. Once that matter is not discussed, and see, you can prove that, you can learn that they discussed that matter. And maybe you have a recording of it, or somebody heard it and the person can come back and say that they discussed that matter. Someone discussed it. There's nothing wrong with it. But
Kanse we no yama enkomodie na kwae nanu ya de ye twam okay ayi bra ye de ora to force mu case ne court no japa mo recording be e bae said the attorney general mpo ene judge or not case ne so akwakosia asa yare na akwakoya de kuro ana
na attorney general all that attorney general no na chief justice lawyer say attorney general Kakeja pass uncle court uncle the answer you should go and lie to them that he was sick. Attorney general of the party told Jakpa that go to court because I wanted to be around but I have trouble. So you go to the doctor and get some fake document, take it to court and lie to court that you are sick so that they will adjourn the case so that I'll be around. So before you testify and you say things exactly the way this same attorney general they say he's saying that what he's calling on people that the good people in the country should speak out about what? Speak about the president doing the right thing. The constitution says that look, unless the president Angie petition the petition will get back the law you have to follow the law. The law says that the petition will bar refer it to Council of State, set up a committee. Now the case that the Supreme Court decided that if the petition comes, we should determine prima facie case first. We should let the Chief Justice see it. And as soon as the petition comes and the president says, "Oh, I've received 3 petitions," they run, give. Tell the president because they thought that the president will not give copies of the petition to the Chief Justice because constitutional on copies. It is only a different case, a J2 case that says that they should. If they receive a petition, they should give copy to the Chief Justice. And they think that the president will hold on to the constitution strictly and will not obey the J2 case. That is why they did that. Their press conference quickly, they filed a case. But before they filed a case, the president said, copy. Now, you should respond to it. Now, Chief Justice asked for 7 days. The president gave 10 days. And he gave you. And she did all of that. The Constitution says that the President and the Council of State should determine prima facie. The way they have to do the prima facie, the Supreme Court doesn't say it, didn't say so. The Constitution also doesn't talk about it because on Chief Justice, the second relief is that the prima facie was not determined properly. The suit are filing and one. And we second when we say almost the prima facie that the president, the Council of State, are determined. They didn't do it well. They didn't publish it. But there's no process anywhere in any book in the Constitution and in the judicial case that the president, the Council of State, say now
determine prima facie case.
It just says that you should determine prima facie, and so that their own process, they can just read the thing, look at the Chief Justice response, and then say that no, and they voted or whatever, the Council of their voters, no, we realize that no, when we look at this, there's a prima facie. And mind you, there are lawyers on the Council of State. The chairman was the Speaker of Parliament before, and he's a lawyer. And there's also a former Chief Justice, all of them were there, and then they voted in determining prima facie. If now they are coming to say that, oh, the prima facie, they didn't determine well, they should tell us how it should be determined. And the thing they are saying is that they are reasoning and everything should be handed to the Chief Justice, how they determine the prima facie and all of that. That is not in the law anywhere. Now, only the Anka President, Anka Mundi, what paper be and reasoning be and my Chief Justice, so this is how we determine the prima facie. Anka, they will be challenging that one in court right now. And the process, no, it will move. Oh, and in the premise of the Constitution, they know all of this. That is why they made it very strict. So, President, in fact, if they wanted to move strictly according to the text of the Constitution, if the President receives the petition, the President can even decide not to even open the petition at all. So just form a committee straight. That is what the Constitution says. Article 146. It says that when you receive the petition for removal of the Chief Justice, in consultation with the Council of State, form a committee. You see, it doesn't even say they should even do a prima facie. I want this one to be very clear. The prima facie case, it is required for the removal of other justices apart from the Chief Justice. But don't you hear? That is Article 146, 4 and 5. It says that when there's a petition against the removal of any justice of the Superior Court other than the Chief Justice, the President will refer the petition to the Chief Justice. And the Chief Justice is the person that will determine the prima facie. And so if we determine the prima facie, then they form a committee. But when it comes to Article 146, it says that if the petition is in the respect of removal of the Chief Justice, when the President receives it, President with consultation with Council of State must form a committee. There's nothing, no mention of prima facie at all. The President here, your team for this, you understand this. So this thing, you see, we are not looking at it very well. But the reason the prima facie thing came in is that when there was an attempt to remove a Chief Justice before, that's the Adjechum case, and the matter went to court, then the Supreme Court said that they were trying to protect the Chief Justice at that time. So they looked at the thing and they said, oh, one say the removal of other justices, there's a requirement for prima facie. Why is it that there's no requirement for prima facie if they want to remove Chief Justice? And the Supreme Court, they say, and we per se, if they want to remove Chief Justice too, there must be prima facie. So it is a new case that has introduced this prima facie case in the removal of the Chief Justice. Do you understand what I'm trying to say?
Yeah.
And say, your Constitution say, who be Article 146, even right now, and you read, you will not see anything about prima facie, the removal of Chief Justice. It just says that when the President receives the petition, in consultation with the Council of State, he must form a committee.
Okay.
But the Supreme Court confused the whole thing and said, no. Even though the Constitution doesn't say there should be prima facie, we think that once there's a prima facie determination for removal of other justices, if it is for Chief Justice, we think that there must be prima facie. So it is a judicial case, and that is why when this petition, the President announced that he received this petition, that's why they were afraid. They were thinking that the President will not obey the Adjechum case. He will just go by the text of the Constitution. That's why quickly as a ran to court.
Okay.
And so that they have to give the petition to Chief Justice. The President, I knew about this Adjechum case.
But
when I'm going to give it to her. So what's your problem?
Counsel,
and then that case also died.
Counsel, in halting the process, no, say EBNU, say antics, no, we enra,
yes.
4-1 by, no, I didn't change cry, a filing new one, to be another president at once when you quiet, the SOA.
Radio. 81. I don't have abuse of process, abuse of the court process.
Okay.
Because if you look at the relief, the relief meaning the same, very similar. Now the end result is the same. Now the court, the attitude of the court right from the onset is that they are not in the mood to grant any injunction on the process. Now by now they have determined about 3 different injunction applications already, all similar. How they filing the same thing again? Now, until we say a strategy. Now, strategy was everyone say. Once at the Supreme Court, there are various, there are a number of justices over there.
Yeah.
So maybe they are hoping that maybe they will be changing the panel, and if they change the panel, if they are also the first injunction on dismissal. Now, 3-2.
Yes, 3-2.
3-2. Now, the panel that determined the one yesterday is a different panel. 4-1.
Yeah.
If they are hoping that if a new application comes, there will be a different panel again. Maybe there are some justices over there that may be favorable to the chief justice, and now we don't know. But people are thinking all of that. That if they will come on the so if they come, by the time you realize they may win, and then they will stop the process. That is the hope. But you see, this is the Supreme Court. The Supreme Court itself, they should maintain their dignity. One said in 3 separate applications for injunctions, they have knocked it down. They have to hold on to that position. Even this process, they have to even let them know that, look, we have looked at applications and all the things that the Chief Justice is asking for. They were part of the ones that we have looked at already. And the other thing that you are bringing new one. And if they decide this one also, we will find another one again tomorrow.
But
they are just abusing the process.
Counsel, these are lawyers and our judges are a call law school. No, say your fair be constitutional constitutional order and I say constitutional mandate. Yeah, constitutional mandate. And in so doing, President exercise a constitutional mandate. Yes, sir, to me confirm before for the stop the constitutional mandate of the president.
At all. If the president is performing his constitutional duties, you can't stop the president. You see, and not been a chief justice in the past administration when even Parliament perform their duty, and then they have to even take the bill that was passed in Parliament to the president, and then they file a process to stop the bill from going to the president in the court. The chief justice refused to hear that matter. The constitutional matter, they only have to pass the thing to the president. But you stop it, you refuse to even schedule it for hearing until the president lost election, and then now you rule and say it's the same thing they did for Domelebu. When they sacked Domelebu, we filed processes, we went to court, we did everything, and they refused to decide the case. When everything was done, Domelebu was effectively sacked, he's gone home now, then you rule and say, oh, the president shouldn't have sacked him. If they are acting, they are going according to the law. Otherwise, every time people will just run to court, if the president wants to perform any of his duties, somebody will just run to court and say, no, injunction. Then the president is not going to work.
Okay.
But we have elected the president to work.
That's
and
right.
the president swore an oath and said that he is going to uphold the principles of the constitution. Ghanaians, you have elected me, and this is the constitution you said I should pray. I'm going to pray. Anytime the president wants to pray, why should somebody run to court and say, don't do it?
Injunction.
And that is why the court doesn't allow that. If the president does it, and then he didn't do it right, you can go to court and say that he didn't act on this provision very well. But anytime you want to act, you want to court. No, stop it, stop him. Don't let him do his work. Don't let him form the committee. Don't let him dissolve the committee. Don't do this. So what work is the president supposed to do? He just sit down there and fold his arms.
That's right. Council medicine when about what anope watching minim said the position that the law is the law. Asisana.
The law is the law. The law is the law. Yakura links or cry there. We will do another press conference very soon and let Ghanaians see that the law is the law, and so they should allow the committee to work. If the committee works and they see that there's anything about the committee's work that they have to challenge in court, they are free to go to court. Okay. But now they are just trying to truncate the process, trying to confuse everybody, and they don't want the process to go on. Today shoot, another time shoot, tomorrow shoot, and lawyers are doing this.
Council medicine, let's have a